Okay, now, please identify yourselves for the record.
Matt Way, Prosecutor's Office.
Danielle Lagore, Family Services Children's Aid.
Ivan Brown on behalf of Bobby Joyner.
On behalf of Catherine Hurl, mother.
And I'm Catherine Hurl, mother.
Anything
Rebecca
preliminary?
McCluskey.
Sorry,
Rebecca McCluskey for Timothy Williams, lawyer guardian ad litem. Thank you.
Other than the request that the court take judicial notice of the file, which I will do, is there anything else preliminary, counsel?
No, Your Honor.
No, Your Honor.
No, Judge.
Call your first witness, Mr. Way.
Call Danielle Lagore.
Ms. Lagore, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your full name and spell your last, please.
Danielle Lagore, L-A, capital G-O-R-E.
Ms. Lagore, you filed the petition in this case, the supplemental petition in this case, is that correct?
Yes, sir, I did.
And at the time you filed the petition, was everything in it true to the best of your knowledge?
To the best of my knowledge, yes.
This court currently has jurisdiction over Hayden Joyner, date of birth 7/9/2014, is that correct?
Yes,
And Hayden's legal father is Bobby Joyner, date of birth 9/1/1979, is that correct?
yes, it is.
And his mother is Catherine Hurl, date of birth 3/4/1990, correct?
Correct.
I know we're dealing with a couple different timelines, so I want to make sure we get those correct. Hayden was initially removed from his mother, and his father was not, that was back in December of 2017, is that right?
Yes,
And
He
his
was-
father was a non-respondent at that point, correct?
initially he was, yes.
Okay. Adjudication for Ms. Hurl was back in January of 2018, and disposition occurred in February 2018, correct?
That is correct, yes.
And at that time, she was ordered to participate in random drug screens, a psychological evaluation, parenting classes, mental health services, and inpatient substance abuse treatment. Is that correct?
Yes,
Hayden was then removed from Mr. Joyner back in about 6 months later, back in June of 2018, correct?
yes, he was.
And the concerns were the same with Mr. Joyner at that point, substance abuse and mental health. Is that fair to say?
Yes,
Disposition for Mr. Joyner occurred in August 2018, where he was ordered to participate in a substance abuse assessment, random drug screens, parenting classes, obtain and maintain housing and income. Is that correct?
yes, we also asked if he would participate in a psychological.
Okay. Let's talk about Ms. Hurl first. Was a referral made for drug screens for Ms. Hurl?
Yes, multiple.
And I believe the report indicates the drug screens occurred at with three different providers, Forensic Fluids, AverHealth, and Adam, correct?
That is correct, yes.
What was Ms. Hurl's compliance with drug screening through Forensic Fluids?
Through Forensic Fluids, she missed about 112 out of 135. And this is from the period of February 2018 to late December of 2018. So that 2018 year, the state had contracted with Forensic Fluids, and that's why there's so many different companies. But she tested positive for 20 screens, and she was positive or no-showed to about 98% of her total screens.
Okay, so she only provided a negative sample during that time period for 3 of 135 screens?
Yes.
Okay. And then there, then or the agency or the state, I should say, contracted with AverHealth, to conduct the drug screens around early 2019. Is that correct?
Yes.
Okay. And did Ms. Hurl participate in any drug screens through AverHealth?
She did not, no.
Was she referred for those?
I'm sorry.
Was she referred for those?
Yes, she was.
And then the petition indicates that in July 2019 through October 2019, Ms. Hurl did drug screening through Adam. Is that correct?
She did, as part of her probation, participate in some drug screens through Adam.
Okay.
She
And
only
what was her participation like through Adam drug screening?
still largely inconsistent. She participated in 9 out of 21, and she did screen 12 times negatively.
Okay. In terms of her substance abuse treatment, Ms. Hurl participated, or there was an attempt to engage Ms. Hurl in several rehabilitation centers. Is that correct?
Several, yes.
And can you explain to the court which facilities she was referred to and what her success was at those facilities?
She participated inconsistently with FSCA's SUD provider, Born Free, and she never consistently engaged, and she was discharged in May of 2018. She never re-engaged to complete services with Born Free. She participated in multiple inpatient rehabs. She was referred through Henry Ford. She did rehab through TRICAP. She also did things at Sacred Heart and Hope House. She started inpatient at Washington Way, but left after 24 hours. So she has not successfully completed any SUD services.
Okay. And when you say SUD, what does that mean?
I'm sorry, substance use disorder.
Okay. Did Ms. Hurl participate in a psychological evaluation?
She did. She participated with Dr. Lauder in May of 2018.
Okay. And did Dr. Lauder recommend anything that wasn't part of her court or the court orders for her service plan?
The only thing that she specifically recommended that was not previously ordered was that she adhere to psychotropic medication prescriptions and her psychiatric care.
Okay. And where was she receiving psychiatric care through?
Initially through Lifeways, but she had no showed too many times they would not keep her as an active client.
When did that occur?
I want to say, I'm going to check the petition. Is that okay for the date?
Would that help refresh your recollection?
This is a long case.
Sure. Go ahead.
It was April of 2019.
Okay. Was Ms. Hurl referred to parenting classes?
Yes, multiple times.
And did she complete those parenting classes to the best of your knowledge?
She completed parenting classes through TRICAP, but it was not through an approved agency that I could get any kind of follow-up on or any curriculum that I was familiar with. So I personally would not count that as a completed class.
Did you attempt to follow up with TRICAP regarding those parenting classes?
Yes, I got a certificate, but I couldn't speak to the curriculum or her engagement.
Okay. It appears that Ms. Hurl is incarcerated currently. Is that correct?
Yes.
Do you know why she's incarcerated?
Her former probation officer reported that she was incarcerated resulting from an overdose in January of this year. And it was reported that she refused to go to inpatient as recommended. So she was sentenced to a year.
Okay, and when did that sentence occur? Do you know?
I want to say it was in April of this year.
Do you know when her earliest release date is?
I do not know.
Okay, and but she is in the county jail, correct?
Correct.
Okay. Do you believe that Ms. Hurl has made any real progress rectifying the conditions that brought Hayden into care?
Not sustainably, not consistently, no.
Okay. Do you still have concerns regarding her substance abuse?
Absolutely, yes.
Are you aware whether Ms. Hurl has appropriate housing or income at this time?
At this time, no, she's still incarcerated. So she could not provide care and custody to Hayden until her release date.
I want to talk about Mr. Joyner now. The petition indicates Mr. Joyner participated in forensic fluid screening from July 2018 through April 2019. Is that correct?
Yes, he did stop participating in January of last year, though.
And what was his level of participation in those random drug screens?
He no-showed 85 out of about 120 times. He stopped, as I said, in mid-January of last year, stopped participating. Oh, I'm sorry, Ivan Brown, did you want to say something?
No,
Oh,
No.
I'm sorry, I thought you had pointed your finger. He had about 7 screens positive for cocaine prior to ceasing in his engagement. So he failed to attend or was positive about 76% of the time.
Okay. And so when there was a switch from forensic fluids to AverHealth drug screening, did Mr. Joyner participate in any of the AverHealth drug screens?
To date, he has not participated with AverHealth at all.
Was he referred for a substance abuse assessment?
Yes, multiple times.
And did he participate in any of those?
He did not. He at initial removal, he was referred to inpatient treatment. And I assumed that they did a substance abuse assessment, but he never provided verification of that as requested.
Was Mr. Joyner referred for a psychological evaluation?
He was, and that was scheduled in September of 2018, but he no-showed with Dr. Lauder, and he to date has failed to pay the rescheduling fee in order for a new appointment to be created.
To the best of your knowledge, has Mr. Joyner participated in any sort of parenting classes?
I want to say that he started, but did not get past 1 or 2 sessions, so it was not completed.
And are you aware whether Mr. Joyner has appropriate housing at this point?
He has insufficiently responded to my efforts for over a year. Placement reports that he does, but that has not been verified by the agency.
Okay, I believe your petition indicates that somehow you've been provided with an address for his house. Is that correct?
Yeah, I've had multiple addresses for him, but I've had mail returned. I went there and I went to an address that didn't exist. So it's, like I said, it's never been verified. I don't know about his housing situation at all.
Have you been able to do a home study of his home?
No.
Has Have you had consistent communication with Mr. Joyner?
I will say initially when he returned from his halfway house in Port Huron, I had great communication with him for about 4 or 5 months. Since then, very inconsistent, very insufficient. He has not participated with the service plan or with communication with the agency.
Based on what you've been able to verify, do you believe that Mr. Joyner has rectified the conditions that led Hayden to come into care?
I do not know.
And where is Hayden currently placed?
Hayden is in a relative licensed foster home with his paternal grandmother.
The goal initially, for quite some time, I believe, was guardianship. Is that correct?
Yes,
And was guardianship paperwork filed with the state?
yes, it was.
Okay, was a subsidy requested from the MDHHS subsidy office, whatever that's called?
Yes, it was.
What
It's
was the
called the
result
guardianship
of that
program.
request?
I'm sorry, can you repeat that question?
Yes, what was the result of the request for subsidy?
Oh, this DHS chose to deny the subsidy, so I filed an appeal with placement in April of this year, and that was also, the denial was upheld.
And what was the reasoning? Did you receive reasoning for the denial?
Yep, the office stated that adoption was not appropriately ruled out, and they really stressed that guardianship in this case was not intended to be permanent until Hayden was 18. I think that it was everyone's intention that Katie and Bobby would get to the place that they could take care of Hayden. And that the office saw that as that it would not be a permanent solution.
Was Hayden's young age a factor in that decision, if you know?
I think it is a factor. I don't know if it's one of the main reasons it was denied though.
Okay. Relative placement, if everything was equal, and they were able to get the city, does placement support a guardianship?
Yes, obviously that was the hope, but they do I mean, she relies on the financial assistance, so she needs some kinds of subsidy to make.
Okay, and so without a subsidy, is she comfortable with a guardianship long-term?
She is comfortable, but we had to recommend against that because of her financial situation.
Does placement believe that she would be able to care for Hayden long-term without the subsidy?
No, it would be a struggle.
Okay, and as a result of that, do you now believe that adoption is the most appropriate goal for Hayden?
As a direct result of the denial, yes, I do believe that.
Okay. Do you have any concerns with Hayden's well-being in this placement?
I do not know.
Does Hayden have a strong bond with placement?
Yes, very much so. Very much so.
I didn't ask about parenting time. When's the last time the parents have seen Hayden?
The father, Bobby, he participates very regularly in the home. The foster parent supervises that contact. I would say almost every day contact of some sort via phone, in person, in the home or at the lake. He engages very regularly. He brings outfits, toys, things. I would say they have a good relationship, but Jeannie still provides that stability and consistency. Katie has not seen Hayden in, I want to say since January of this year. And throughout the duration of the case, her parenting time has been very inconsistent. There were some periods where parenting time was suspended and she never moved past supervised visitation.
Do you believe, how would you classify it, given that the bond between the mother and Hayden at this point?
I would say on Katie's part, she does have a very special bond with Hayden. She loves him. It's her firstborn child. I think for Hayden, what I've observed is he's at home with placement. I think he could take it or leave it at this point.
What do you mean by that?
I mean, his contact with her has been very inconsistent. He doesn't ask about her. He doesn't want to see pictures. I think it's just been a long case and he's comfortable at home with his placement.
Based on what you stated about Hayden and his father, I'm guessing that there is a bond between the two of them.
Yes, I've observed that to be definitely more healthy than the maternal bond, unfortunately.
Okay. Have you observed a stronger bond between Hayden and his placement?
Yes, absolutely.
Okay, does Hayden look to his placement for his care and love and all of those type of things?
Yes, absolutely. He communicates his needs. He responds to the foster parent's comfort. She meets his needs. I don't have any concerns about his care in the foster home.
Ms. Legore, do you have an opinion as to what's in Hayden's best interest as it relates to his parents' parental rights?
I think it's the agency's recommendations that obviously that the rights be terminated. Hayden has been in care for a long time, over 2 years, and he deserves stability. He deserves safety in a home without exposure to substance abuse, and he deserves permanency. And placement can provide that.
Thank you, Ms. Legore. Your Honor, I have no further questions at this point.
Questions, Mr. Hotchkiss?
Just briefly, Your Honor. Ms. Legore, I think you referenced a department that was addressing your request for an adoption subsidy. You indicated that you were advised that given Hayden's age and the length of time that he would need to be in care, that they did not feel that a guardianship was appropriate because it was long-term. Did I get that correct?
They believe that it was not to be a long-term solution because placement had hopes that parents would rehabilitate.
Okay. And did they consider, if you know, the idea that Hayden would potentially be in placement's care until he's 18 years of age in any event? So in other words, if neither parent put themselves in a position to ask that the guardianship be terminated, Hayden would still be there, and he would be there regardless if it was a guardianship or an adoptive home. Do you know if that issue has been addressed?
I think, I'm sorry, could you ask me the question in a different way?
Sure.
I just don't understand.
In a guardianship situation, there's at least the potential that the parents could put themselves in a position to where they could eventually provide care for Hayden.
Right.
Is that correct?
That is correct. And the fact that that premise exists at all in this case is one of the reasons why the guardianship office denied the assistance. They make the independent determination in hopes that it's going to be to the age of majority, the guardianship. Does that make sense?
I guess I don't quite understand the rationale. Let me see if I can find a better way to ask you this question. Presumably the placement is going to be the adoptive home for Hayden. Is that correct?
Right. That's correct.
And so if the court terminates the parental rights to Hayden, he will be in that adoptive home potentially for another 12 years, correct?
Correct.
And in a guardianship situation, I think you suggested that the department that addresses the subsidy said that it would be the intent of a guardianship to not go the full 12 years, but have Hayden reunited with his parents at some point in the future when they were able to do so. Did I state that correctly?
Yes, and because that was a fact, that's one of the main reasons the department chose to deny, because they see that as the guardianship not intending to be permanent.
Okay. How long has Hayden been in this placement?
Almost 2.5 years.
You had
Two
originally-
were, I'm sorry, what?
You'd originally recommended the guardianship, correct?
I did not. I originally had recommended termination about a year ago. I think we were at the termination trial when yourself and the other attorneys submitted the plan for guardianship. And because placement agreed, we did pursue that.
Were you ever in support of the guardianship then as an alternative to termination of parental rights?
I was, because at that point, the mother was making progress, Katie was, and Jeannie was, she's a relative, so she was able to facilitate the relationship. And I thought it was a good solution at the time, yes.
And would there be any, but for the subsidy issue, would you still support that?
Yes, I would.
Thank you.
Mr. Brown?
Yes. Ms. Legore, I'll just be real brief. The judge instituted the permanency plan of a juvenile guardianship approximately a year ago. Is that correct?
Yes, June 5th of 2019.
Okay. And he determined that it was in the best interest of Hayden that be the permanency plan, correct?
Yes, he did.
And the Office of Juvenile Guardianship, is that an independent office, or is that a come under the umbrella of the Michigan Department of Human Services?
It is under DHHS.
So would it be a fair statement that the judge isn't making a determination of what the permanency plan is, and that your office, not yours specifically, but another branch, is in effect performing a judicial function in this case and determining what the goal is rather than the judge?
Yes, they make an independent decision on eligibility for assistance, and they do not have to align.
So they're making the determination of how this case proceeds instead of the judge. Would that be a fair statement?
They are making a determination strictly about financial assistance, not about a court-ordered permanency goal.
Okay, but the reality of it is, because of their denial, the effect is that they're running the permanency goal on this case, correct?
It did largely affect it, yes.
Okay, and are you aware of case law that indicates that the court is supposed to determine the permanency plan and approve it, as opposed to the juvenile guardianship office?
Yes, I am aware of case law. I'm also aware that the guardianship assistance program has separate qualifications that they have to make the determination by. So they are occasionally in conflict, yes.
That is subjective, though, on their part, correct? There's no totally objective criteria as to whether they're going to grant a juvenile guardianship or not.
I will say they have their policy, but it's not something that I am totally familiar with as far as subjective or objective.
Okay, thank you. I'd have nothing further, Mr. Gore.
You're welcome.
All right, any questions, Ms. McCluskey?
No questions, Your Honor. Thank you.
All right, any redirect, Mr. Way?
No, Your Honor.
Any further witnesses, Mr. Way?
No, Your Honor.
Any presentation, Mr. Brown?
No, Your Honor.
Mr. Hotchkiss?
I've discussed this with my client. She's opted not to testify nor present any evidence. Thank you.
Okay. And any presentation, Ms. McCluskey?
No, Your Honor. Thank you.
Okay, I guess we're ready for arguments. Go ahead, Mr. Way.
Thank you, Your Honor. I recognize this is a very tough case. In terms of the basis for termination, whether a statutory basis has been met, that's clearly true. Multiple termination bases, 19B sub 3 sub J and sub 3 sub C sub I are both clear and convincingly proven based on Ms. Lagore's undisputed testimony. This is a best interest issue, and I understand where everyone's coming from. Quite frankly, I agree with what the court stated previously, that I think the Court of Appeals and or the Supreme Court needs to give us some guidance on this issue. I don't quite agree with Mr. Brown's, what I believe he was implying. I don't think that the guardianship office isn't dictating necessarily what the permanency goal is, but they certainly are affecting it greatly by by their decision to deny the subsidy. In a case like this, where the placement desperately needs that subsidy, it has the effect of forcing the court's hand on what the permanency goal is. I don't think that I do think that there's because they're not directing the court to specifically make a goal change.
You're going in and out. I don't know whether it's your connection or not, but I'm hearing every other word of yours. It's like it's echoing.
Is the court able to hear me?
I have been able to hear you, but occasionally it does cut out.
Okay. So I do believe that there's a distinction that can be made. There is a case that the Supreme Court came out with indicating that the agency cannot have a standard policy for young children on guardianship versus adoption. That I believe is the case here. The subsidy office is separate from a foster care agency's determination on adoption versus guardianship. Ms. Lagore made clear that she would support guardianship if not for the need for subsidy. So I do think there's a distinction that allows the court in this case to find that parental rights is in the best interest. There is a bond between father and Hayden, to a lesser degree between mother and Hayden. That certainly weighs against termination, but I think the continued substance abuse issues, the continued instability weighs far more heavily in favor of termination of parental rights. And I do believe that parental rights, at least by a preponderance of the evidence, is in Hayden's best interest. So I would ask that the court does terminate the parental rights of both Ms. Rowe and Mr. Joyner. Thank you.
Mr. Hotchkiss?
Just briefly, Judge. Now, I would argue specifically as it relates to the best interest that it is not in Hayden's best interest that the parental rights be terminated. Hayden is 6 years of age, has a substantial period of time for mom and dad to turn themselves around Hayden is in a good, stable home, will be in that home presumably until he reaches the age of majority. But for a policy decision with respect to funds, a guardianship would be perfectly suited in this matter. It's not easy to set aside a juvenile guardianship, and certainly the court would have the ability to evaluate the parents at that time. It's unfortunate that we have a bit of, it's kind of a quirk, I'll call it, in the law, even though it's not really a quirk, but it's a policy in the law that would thwart this court's decision with respect to what's in Hayden's best interest. The court has previously found it not to be in Hayden's best interest because of the placement. And so I would ask that the court not terminate parental rights and that allow them to move forward with the guardianship. Thank you.
Mr. Brown?
Yes, just briefly, I'd like to tag on what Mr. Hotchkiss has indicated. Mr. Way puts forth that he thinks there's some distinction. I just don't see it. What you're having, the reality is that the Michigan Department of Health and Human Services, although in a different office, is dictating to this court a judicial function of establishing the permanency goal because they hold the purse strings. The case law, as Mr. Way indicated, that an age limit cannot be the sole determining factor. And during our discussions, it wasn't mentioned during the trial, but there was some discussion from SCAO that some directive from SCAO, but SCAO is not in charge of interpreting the law. This court is. So I think SCAO has kind of outstepped their bounds by issuing a directive like that. Their function is procedure and court policy, not interpreting the law. That's outside of their bounds. So I would ask that the court abide by the case law and not let the Department of Human Services dictate the parameters of this case. They've made the decision for you. You made a decision before that guardianship was in the best interest of this case. You've been here, you've heard all the testimony, you've been involved in this case for 2 years. We are now letting the petitioner dictate what this case, how this case ends. That's not correct. We need an impartial arbiter of this case. They're occupying two functions, the judicial function and the petitioner function. So I would ask that the court deny it and issue a directive to the juvenile guardianship that they shall issue a juvenile guardianship in this matter. Thank you.
Ms. McCluskey?
Your Honor, I would just say, obviously, we are seeing this situation quite frequently, and I do find Mr. Hotchkiss's and Mr. Brown's arguments compelling, but otherwise I would leave the decision in the discretion of the court. Thank you.
All right, and I realize, Ms. McCluskey, you're in a bit of a tough spot, having to cover for Mr. Williams as LGAL. I know, based on arguments he's made in the past, that he strongly supports juvenile guardianship, and himself has expressed frustration with the fact that the Guardianship Assistance Office has essentially usurped the role of this court in determining what's in the best interest of this child. I'm sure if he were here, he would be advancing those identical arguments that he has previously voiced that are in the record. Mr. Way, any further argument?
I mean, I just, in response to Mr. Brown's argument, I just want to make clear for the record that Neither myself nor Ms. Legore nor anyone involved in the foster care process is at all involved in the decision-making on the subsidy. So I think it's unfair to say that the petitioner is the one forcing the court's hand. The subsidy office is a completely separate entity, even though it's in DHHS. So we followed the court's direction. We supported a juvenile guardianship, and I just want that to be clear for the record. Thank you.
Okay, thank you, counsel. First of all, the court has to address whether statutory grounds exist for termination of parental rights. We have several independent bases asserted in the petition. Under subpart 3J, there's a reasonable likelihood based on conduct or capacity of the child's parent that the child will be harmed if returned to the home of the parent. Under subpart CI, the parent was a respondent in a proceeding brought under this chapter. 182 or more days have elapsed since issuance of the initial dispositional order, and the court, by clear and convincing evidence, finds the conditions that led to the adjudication continue to exist, and there's no reasonable likelihood those conditions can be rectified in a reasonable period of time, given the child's age. I believe the facts establish basis for termination under both those subsections. Both parents struggle with addictions and have continued to struggle since well before the case was filed and continuing even to the present. Mother probably is not using drugs now because she's in jail and she can't. She doesn't have any access to them. But there's no indication. The court has zero comfort level based upon the history since adjudication, given frequent failures to complete treatment programs, failure to abide by the conditions of her bond and being sentenced to jail, conditions of her probation rather, participation in drug screens that was minimal at best, and testing positive on the few occasions, or many of the few occasions when she did submit to a test. The father had the same problem. It's clear that his addiction issues continue. He's completely dropped out of the case. His only remaining involvement is that he continues to see his child, which is understandable since the child is placed with his mother. This is a very frustrating case for the court. When termination was first requested, the court, even though finding that proper grounds or believing, I can't remember if I got to the point of a finding on the record or not, but it was clear from the dispositional hearings that led up to the termination hearing that these parents were not on board, and they weren't going to get on board in a reasonable period of time to address the problems that brought Hayden into care. One of the things the court has to consider in determining whether or not termination is in the best interest of a child is placement with a relative. I have to address that. In this case, we've got placement with a relative. We've got a relative who's shown she can keep the child safe, but has also shown compassion for both parents and willingness to allow them to see the child under supervised conditions. And the court can only assume that's going to continue into the future. So we almost always in that circumstance, when I've got a relative who is willing to serve as a juvenile guardianship who intends to allow the parent to still be involved in the child's life, which they have every right to do as a guardian. In fact, they have every right to do even if the goal is adoption. The parents will, to the extent they're healthy and safe and make themselves available, they're going to be allowed to see this child. The child knows these are his parents. And despite the fact that he is well bounded with the grandmother, he still has a bond with both parents. Obviously a strained bond, especially with mom since she's been in jail and was inconsistent with her visits before, but clearly seeing his father almost daily. When I consider that, that residential placement with a placement that's willing and clearly intending to keep the parents involved in the child's life, that weighs heavily against termination being in the best interest of the child. When we talk about permanency, where it comes most into focus is when a child is placed somewhere with uncertainty as to whether or not that's going to be a permanent placement and is constantly drawn back to the idea that he or she may be allowed to go back with the parents, there is a lack of permanency. When we have a foster parent who's willing to adopt and is a non-relative, once I terminate, there aren't any more visits. That's the end. And a child is now able to get accustomed to the idea, this is my permanent home now. I'm going to be here. Where a situation like this exists and the relative stays involved, clearly Hayden can know that he's going to live with his mother until he reaches majority, but his parents are still going to be able to be involved and around him. So in this case, what happened is the Office of the Juvenile Subsidy, whatever it's called, and I know from past instances, they, consistent with a Department of Health and Human Resources policy that disfavors juvenile guardianship as a permanency plan when the child is of a younger age. I've heard it over and over and over again. And I know they're now trying to distance themselves from that policy, but in fact, I'm firmly convinced that that policy is behind their denial of a subsidy. So I'm forced with a decision today to force a grandmother who has limited means to provide for this child in a guardianship without a subsidy over an adoption where a subsidy is virtually guaranteed. So the sole determining factor for me today as to whether or not termination is in Hayden's best interest is whether or not his guardian is going to be able to adequately care for him. If I had a situation today, which I often have, where the grandparent placement has sufficient means to care for a child, a lot of times we don't even do a juvenile guardianship. We do an epic guardianship because there's no issue with a subsidy. So here, the caregiver who's well off financially doesn't need a subsidy, and therefore there's no problem granting a guardianship. We're not dependent upon the department. But here, where I've got placement that is unable to provide adequately for the child. Now, what's happening is the placement of lower income is actually being discriminated against by the department's policy. There's no question in my mind today that if Grandma had the means to care for Joyner, for Hayden Joyner, I would be ordering a guardianship. I think the guardianship, but for the finances that are available through adoption subsidy, when it's not available through the juvenile guardianship subsidy, I would find that termination is not in Hayden's best interest. We've got the department saddled with a policy that our Supreme Court has already criticized of disfavoring juvenile guardianships with younger children. That's driving the bus. They're not required to grant or withhold a subsidy based upon considering the factor of whether the child is in a residential placement. They can ignore that. They can ignore what I've been told in numerous appellate opinions that I must consider. So I have considered the residential placement. I find that but for the absence of a subsidy, I would find that a juvenile guardianship is in Hayden's best interest. But because the juvenile guardianship has been denied by the department, and because Grandma is not able to provide for Hayden adequately without the subsidy, I'm ruling today for that reason and for that reason alone that termination is in Hayden's best interest. I sincerely hope that our appellate court, Court of Appeals, or ultimately our Supreme Court gets a chance to look at this case and rights what I believe is a terrible wrong, a terrible injustice as a result of DHHS blind adherence to a policy that favors adoption as a permanency plan over juvenile guardianships for younger children. I'm going to set this matter for a post-termination hearing, August 11th at 9:45. Ma'am, I truly hope that you're able to beat this addiction. I wish you well. I hope you are.
Thank you.
I understand the horrible grip that opiates have and drugs can have on people. What a challenge it is, but I hope that this extended period of drying out and being away from it, and then after you get done, get whatever more help you need. I heard from what I consider a very valuable source. I don't know if you've heard of Andy's House or Andy's Angels, but a father who lost a son to opiate addiction, who the last time he got out of a short-term treatment program, within hours or days, shot up and died of an overdose. And what I learned from his father, who embarked on a lengthy program of trying to understand, why did my son do this? Doesn't make sense. He grew up in a good home. He had everything going for him and did well when he was in the treatment programs. What he learned is that opiates in particular do something to your brain. And in order for you to really break free, you have to stay free for 2 years or more, 2 years of sobriety before your brain starts settling down and working correctly so that you can make a rational decision about whether you ever want to get high again. So a year in jail isn't going to do it for you, ma'am. I would urge you, the moment you get out, seek a program like Andy's house, and I don't know the status of it. Has anybody heard whether that's been completed? I know it got waylaid because of coronavirus and the construction got put to a halt. Has anyone heard?
Looks like they're still working on it.
Still working on it? Well, maybe it'll be done by the time you're out. Check it out. Check it out, ma'am. I wish you the best.
Your Honor, with respect to my client's appellate rights, is there a way that she can get a form today and
Yes,
sign that?
absolutely. Shannon, could you generate the form she would, is it, it's the notice that she'll get today? Whatever form that is.
And I am wondering where my client would go to pick it up, and who he should seek to pick up his appellate rights.
We can mail it to his last known address, but we can also mail it to his mother.
I would prefer
he's-
mailing it to his mother, and I was going to ask Miss Legore if she could provide me with his mother's telephone number so I can attempt to reach him.
I'm happy to do that. I'll send an email right now.
Okay, and if you would tell her that her son's attorney will be calling her to talk about this matter.
Yep, I will do that. I also believe she's watching.
Okay, thank you.
Where am I sending it to?
Will you,
Do we, let me check the file and see if we've been getting things returned. Would you mind, Ms. Legore, emailing Shannon the placement's address? I don't want to put that on the record.
Yep, I can do that.
Okay, who am I addressing it to? Father then?
Address it to the father, care of, what's the mother's name? Grandmother's name?
Oh, Jeannie Mallory.
Okay, can we spell that, please?
Mallory, I'm sure is Mallory.
Correct.
How's she spell Jeannie? Normal way?
Capital Jeannie.
All right.
Okay, and mom's will be delivered directly to her today. I do need to tell you on the record, ma'am, what your rights are. You have the right to request a rehearing from this. This is the, oh, it's the wrong one. Shannon, can you print the advice of rights form? All I've got is the release advice of rights.
Which advice or rights form? The one that I just gave mom?
Yeah, because I have to put it on the record. I don't have anything to refer to.
can you grab the other one? Don't have no key.
Okay, ma'am, this is on the form that's been given to you. You have the right to appeal termination of your parental rights directly to the Court of Appeals within 14 days of today's date. You also have the right to file a motion for rehearing with this court also within 14 days. If you choose to file a motion for rehearing and you do so in a timely manner, you would have an additional 14 days after denial of that motion in which to perfect your appeal to the Court of Appeals. An attorney for appellate rehearing purposes will be appointed for you. If you can't afford an attorney, the court will appoint one for you. So you've been given the form. It looks like you're already filling that out. So your obligation to support your child will continue until a court of competent jurisdiction modifies or terminates the obligation, until an order of adoption is entered, or until your child is emancipated by operation of law. In addition to those rights, you have the right to control the release of identifying information about yourself by the Central Adoption Registry of the Michigan Department of Health and Human Services. You can consent to or deny the release of information regarding your name at the time of termination of your parental rights and your most recent name and address on file with the agency. You can use the form at any time you change your mind about consenting or denying the release of information, and you can use the form to keep your name and address current with the Central Adoption Registry. I believe that concludes our hearing. Thank you all.
Thank you, Your Honor.
Thank you.
Thank you, Judge.